You mentioned here that there have been a lot of rulings post-Bruen, a lot, and especially compared to that period between Heller and Bruen. What are some of the biggest rulings in your mind? What are some of the biggest cases that have come down thus far?
Well, I think there's a whole host of them, and they come all over the country. A lot of these occur even in the so-called blue states. And I just want to say before I drill down into what I consider the big ones, judges in the American system or the English system, which is known as the common law system, which means that case law builds upon case law, builds upon case law, which means Judge Gutowski makes a decision. Judge Smith looks at your decision and bases his decision on that. Then Judge Sotomayor bases a decision on that. And then Judge Barrett makes a decision based on that. So there's a building block process where every case decision becomes a precedent, which is analogous to like a brick. And every legal case in favor of the Second Amendment is another brick building up support and protection of our right to keep and bear arms. So with that in mind, what happens is because we've had so many judges have stepped up and applied NYSRPA Bruen versus Bruen correctly in support of the right to keep and bear arms, I think what you're seeing is other judges are seeing the prior judges ruling in favor of our rights, and they feel more emboldened, like, hey, I'm on the right path here. I'm not an outlier. And what we're seeing all across America is judges relying upon other judges to advance the right to keep and bear arms in a way that we hadn't seen in the decade before NYSRPA versus Bruen. And that is making a big decision. And I like to talk about this on my channel, The Four Boxes Diner, that every one of these victories for the Second Amendment emboldens and encourages and reminds other judges that this is how you do it. You're not out there by yourself, being some, crazy person, outlier judge. You're doing what everyone is doing because it's the way it's supposed to be done. But as to the major decisions, I think there's a ton of them, depending on how you want to look. But I mean, look, let's just take a look, for example, in Oregon. Even though you had a federal judge that on TRO did not get it right when it comes to so-called large capacity magazines, which is, are standing capacity magazines. If you look at the state court judge in Oregon, he felt comfortable enough under the Second Amendment through the sort of the states. He used the states' constitutional rights there, but basically a lot of his analysis seemed to had a feel of NYSRPA versus Bruen. He enjoins this entire referendum that was enacted in November by the people of Oregon, so to speak, to violate constitutional rights. And you had a judge that felt comfortable saying, no, this is not right. This is not constitutional under the Oregon Constitution. And he enjoined the entire law. And then the Oregon Supreme Court says, yeah, we're going to let this go forward. We're not going to intervene. If this lower court judge thinks there's a problem under the Constitution of Oregon, we're going to let that lower court stand in favor of gun rights and gun owners. And I think that's kind of an illustration of how judges that recognize the importance of the right to keep and bear arms and the fact that it is a constitutional right, a fundamental constitutional right on par with the right to free speech, the right to a free press, the right to religion at the church or the mosque or the synagogue of your choice. I think we're starting to see the implications of the Supreme Court really putting their foot down in June of 2022 in Bruen and saying, enough is enough. You respect this right like the rest in the text of the Constitution.
Yeah, you've seen that sort of logic play out in a number of cases, right? The Fifth Circuit case on domestic violence restraining orders and the gun ban associated with that. There was also there was a case out of Texas, a federal case that dealt with the prohibition on obtaining firearms if you're under felony indictment but haven't actually been convicted of anything yet. And both of those cases, I think they really get at this idea of these rights are, the Second Amendment rights are on the same level as First Amendment rights or any other rights contained within the Bill of Rights. And you need a higher level of evidence and scrutiny in order to take those rights away. This sort of seems to be a common theme in a number of these rulings so far. I mean, is that
Absolutely.
Do you see it that way as well?
Stephen, just going across the country, we have, obviously certain aspects of California's crazy gun control law remains, enjoined by Judge Benitez out there in district court in California. We just talked about the Oregon temporary victory where, the Oregon referendum in terms of gun control was enjoined. We see in Illinois where, Governor Pritzker helped pass a so-called assault weapon ban. That has been enjoined on the grounds that is unconstitutional. Then we see places like Colorado, where you had actually two Democratic appointees to the federal bench. I think one was an Obama judge. I think one was a Biden judge, and they both enjoined so-called local assault weapon bans in the state of Colorado. In New York, we know what's up in the Second Circuit getting argued on March 20th. But in New York, you had multiple decisions, both by Judge Sinatra in federal court in Buffalo, but also Judge Sotheby in the Northern District of New York, which I think he was in the courthouse in Syracuse, enjoining the so-called sensitive places rules about where people with concealed carry permits are allowed to carry a gun, where they're not allowed to carry a gun in places like Times Square, and so on and so on. We also have seen victories, against the ATF. For example, Cargill versus Garland, although that's technically a regulatory decision applying like the Chevron doctrine and questions about the rule of lenity and what authority the ATF has. But that was a terrible blow from the point of view of the ATF in favor of gun rights in that case of Cargill versus Garland. And that involved, of course, the bump stock ban, which was, to me, unconstitutional and illegal for a whole host of reasons. But again, we saw a major victory down there. And last but not least, in Joe Biden's home state, Stephen, right, we have a case called Rigby versus Jennings, where a federal district court judge in Wilmington, Delaware, the land of Joe Biden, came out and says, you have a Second Amendment right to make your own gun, and the state's ghost gun law, which is a euphemism for just a gun that you make, that was unconstitutional under the Second Amendment. So this is just a handful of major victories that we've seen here in the United States in the last 8 months or so. And I think there's a lot more coming, because we just had a major argument this week in the Third Circuit Court of Appeals, which is the question of whether or not, in that case, it was a guy who had been convicted almost 20 years ago of a $2,000 misdemeanor welfare fraud. I think he and his wife had somehow filled out the wrong paperwork or improperly filled out the paperwork, and they got like $2,000 in public benefits they weren't entitled to, and they pled guilty to a misdemeanor. And this guy, under federal law, because he potentially could have gone to jail for more than 2 years under federal law, he lost his right to keep and bear arms for life. And the Third Circuit Court of Appeals, based in Philadelphia, heard argument this week, and it seems to me, by every indication, they're not sympathetic to the government's position that says if you commit a $2,000 misdemeanor, so-called congressionally defined felony 20 years ago, you lose your gun rights forever. It did not seem like the court was sympathetic to that governmental viewpoint. And it looks like we may be on the road to a major victory in the Court of Appeals for the Third Circuit coming up in a few months.